Welcome to today's program titled 2026 Employee Handbook Updates, Strategies for the Year Ahead. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Hoffman. Chelsea, please go ahead.
Thank you so much, Kate, and thank you everybody for spending a little bit of your day with us. I want to welcome everybody as the official kickoff of Handbook season 2026. It is my favorite season, very festive time of year. There's a chill in the air. You grab your favorite handbook and curl up next to the fire with a warm mug of Handbook spice latte. We know you love it. That's what we're here for. I want to introduce myself, Chelsea Hoffman. I run our firm's National Handbook and Policy team, and I am joined today by two of my esteemed leaders on this team, Jean Wilson from our Boston office and Kathy Feldman from Los Angeles. We have an enormous volume to cover in a very short time today, and I want everyone to know you are going to get the slides, so don't worry about having to take feverish notes as we go, because we do operate at a breakneck pace. So I want to go through, if we go to the next slide, a little bit of our agenda, which will take us through this introduction. We will talk, as we always do, about some of the federal and state developments that are going to impact your handbooks and policies as we head into 2026. We'll also give you a little bit of a refresh on the importance of an excellent employee handbook, why it's so important to have a great handbook and those addenda, and a little bit more information about what we do at Seyfarth, how we help our clients navigate this very different and challenging space. And then we will wrap up by giving you a little bit of an indication of trends that we're seeing in the laws, as well as what to expect through 2026 and into 2027, which is like tomorrow, basically, if you really think about it. But why don't we go ahead and get started, since we have absolutely no time to spare, with our federal and state developments that are going to impact handbooks and policies. I will kick us off by talking a little bit about what's going on at the federal level, and sort of recognizing that we are in the middle of a government shutdown. There's not a whole lot happening, but I want to make sure that we understand how this does impact our handbooks and policies, and we're going to talk a little bit about how that works. It's mostly through executive orders and through the way that agencies are enforcing various laws. So we'll talk a little bit about the EEOC and the NLRB and sort of what's going on. We know that everything is in obviously a state of flux because we are in a little bit of a shutdown, but also that we don't have all of the key players in place on the EEOC. We know that right now we've got an executive order that the president issued that is directing the EEOC to, quote, eliminate the use of disparate impact liability in all contexts to the maximum degree possible, so that we know there's going to be a lot less focus on disparate impact. And so this is an area where, when we're drafting policies policies, we had always been very focused on the concept of disparate impact. We have an indication that this is something that they're not going to be focusing on going forward. They also, through the press release when the new acting general counsel was appointed, excuse me, when it was appointed, we have some of their current priorities, including, quote, rooting out unlawful DEI motivated race and sex discrimination, protecting American workers from anti-American national origin discrimination, and on and on. And so these are the types of things that we want to recognize are just a little bit of a pendulum swing from the way the EEOC was operating under previous administrations and generally in the past. And so thinking about that while drafting policies, that there are certainly going to be areas where the EEOC ultimately, when we get all the ducks in place and the government reopens, where they're going to be focusing, which is very different than the way it was done before. They will continue to prioritize some of the non-controversial areas like PWFA, the Pregnant Workers Fairness Act, as well as disability and failure to accommodate issues. But we are looking at it from a little bit of a different perspective at this time. I also want to talk a little bit about the NLRB. We talk about the NLRB every year when we're doing our handbook and policy webinar because we recognize what an important role the NLRB does play in handbook policies. We want to make sure that we're not writing policies that the NLRB views as overbroad that would prevent somebody from engaging in protected concerted activity. Obviously, right now with the government shutdown, nothing is happening. No charges are being processed right now. So we're a little bit of on hold. But when and if the government reopens, we will recognize there still isn't a quorum. We still have one current member only, and that term does not expire for a little while. And if we can move to the next slide, we can talk just a little bit about what we're going to be expecting. The acting general counsel has rescinded some of the memos from the previous general counsel, but not that many. And so on the next slide, we really can focus on the fact that we have a lot of uncertainty. Stericycle is still there. Cemex is still there. And so, yes, we have a Republican president, and the expectation is that we will take that very wide swing to the right. But right now, we still have very pro-employee, very pro-union case law that is still board precedent. So it'll be very interesting to see what will happen. And just as a refresh, if for those of y'all who may not recall, we know that with the change of administration, we generally change the NLRB. Under the previous administration, the NLRB was very focused on policies that may have the impact of chilling protected concerted activity. And we anticipate eventually this board will really be focusing on policies, only policies that actually do chill that protected concerted activity, and focusing on the damage caused by that. But again, we're in a state of flux at the federal level, and so it's important to kind of recognize that as we navigate. So why don't I kick it over to Jean, who's going to walk us through our next section on developments in paid family leave.
Thanks, Chelsea. Yeah, so I'm just going to take a few minutes to talk about some paid family leave and, riffing off of what Chelsea said. Part of the reason we have so much of this is because we don't have federal paid family medical leave. And so we're seeing states fill in. So we can go to the next slide. This one is really just here for reference. It's just lets you know where we currently have paid family and medical leave laws. And then on the next slide is what we're going to focus on today. These are laws that have been enacted, but benefits aren't available. And we're going to talk about Delaware, Minnesota, and Maine because they all go into effect in 2026. Delaware and Minnesota, January 1, and then Maine not until May 1st. And you can see that the Maryland law has gotten kicked out to 2028. They just keep kicking the can down the road on that one. So we'll have to see if it ever actually comes online. And so we can go to the next slide and kind of jump into the Delaware program. So the next few slides just provide some basic information about the Delaware paid leave program, and I'm not going to go into all of it, but it is important to note that Delaware, unlike some other states, they have a numerical requirement, so it only applies if you have 10 or more employees whose primary place of work is Delaware. And then, as you can see in this little chart, the type of leave you have to provide is different depending on how many employees you have. So if you have 10 to 24 employees, you only have to provide, in Delaware, only have to provide parental leave. And if you have 25 or more employees, then you have to provide all the different types of leaves that are required. The funding for this is a 50-50 split between employer and employees, and that's going to be true for all three of the paid family and medical leaves that we talk about today. And the other thing that is also similar in all three of these is that you can provide the coverage through a private or public plan. So we could go to the next slide. And, you know, this just kind of gives you the benefit amount. Delaware's a little bit on the low end for its maximum benefit is $900, but that will increase with inflation year over year. One of the things we did want to really note here is that December 1st, 2025, you do need to notify all current employees of the availability of leave and do a poster, and we've linked the leave notice and poster on this slide, which you will get. And then they also have a notice of coordination of benefits, which talks about how your own sort of PTO, STD, parental leave may interact. And the state will provide that if you're using the public option, but it is something that if you use a third-party administrator, you will need to provide when somebody applies for leave. And so then on the next slide, we just have a list of the types of leave that is provided. And it's, you know, what you would expect: bonding leave, parental leave, employee medical leave, family caregiver, and qualified exigency. So very similar to the FMLA, doesn't include injured service member. The one oddity about Delaware is that, so parental leave, you can use 12 weeks every year. And then the other three leaves are 6 weeks every 2 years, which is the only law that we've seen kind of use this 2-year duration. And you can't use more than 12 weeks in a 12-month period. And so then the next one we're going to talk about is Minnesota. And so their paid leave program also goes into effect January 1. And this is, Minnesota's closer to what we see in most other states. You know, it covers all Minnesota employees with very few exceptions. The eligibility is based on level of income. So you have to have made a certain amount in order to be eligible. The benefit amount max is $1,423, so that's a little higher. This one also has a notice that needs to go out by December 1st. And again, we've linked that here. And then, you know, you will need to provide notice to new employees. One thing about Minnesota's notice requirement is that it does also require an acknowledgement. So you'll have to get something signed and back from people. And so we could go to the next slide. And here is what is covered, and it is almost exactly the same as the FMLA, except that it adds in a safety leave. So for things related to domestic violence and similar offenses. And the Minnesota leave, you get 12 weeks of medical leave and 12 weeks of family leave. But in a year, you can never use more than 20 weeks. So, you know, if you use 12 weeks of medical leave and then you were going to take family leave, for one of these reasons, you would only be able to take 8 weeks, not a full 12 weeks. And so we can go to the next slide and talk about Maine. So Maine, not until May 1st. Again, it's very almost identical to the FMLA in what it covers and how it's set up. The maximum benefit is $1198.84. And so that is only in effect until July 1st. For whatever reason, Maine decides to do its adjustments effective July 1st. So this is going to change pretty early on after stuff is ready. There is no notice requirement for current employees right now. You do have to provide notice within 30 days of hire for new employees. And there is a posting requirement that, again, is linked here. And then on the next slide, we just list the types of leave that are available. And again, this tracks the FMLA, but then also includes safe leave, similar to Minnesota. And Maine's is very easy. It's 12 weeks of leave in a 12-month period. So again, very, very similar to the FMLA. And that is it for what we expect for paid family medical leave. We do think that we're going to see some others come online maybe in the next year or two, but this is what we've got, 3 for this year. So, and I'm going to turn it over to, I think, back to Chelsea for some paid sick leave updates.
Yeah, thanks, Jean. Paid sick is another area that I'm sure y'all all know. We see so much variety from jurisdiction to jurisdiction, and there is no solution in sight. We're not expecting to see anything happen at a federal level on this one either. And so we thought it would be good to kind of handle all of the paid sick as one fell swoop in this webinar today. Obviously, I know everybody on here has been to several of our webinars. Our paid sick team does such an excellent job of putting forth all this information, so I'm not going to get into that level of detail, but I do want to talk about the significant changes that have happened over the last year and what to expect for 2026 so that y'all are all in great shape with respect to your paid sick leave requirements and be prepared to draft all of these paid sick leave policies, starting with our 2 brand new laws. On the next slide, we've got Alaska, and then we'll talk about Nebraska, which between y'all and me, I didn't realize rhymed until recently. But starting with Alaska, this is a brand new law. There was nothing in Alaska. Alaska has not been a state where we've seen a whole lot of activity over the last decade or so, but this is a brand new law that's going to provide employees with either 40 or 56 hours a year of paid sick, depending on the employer size. It does have some of the little nuances like a required carryover, even if you're front loading, but you have the ability to cap use every year at that maximum that we're talking about. And this does apply to everybody. What was interesting about this law in true Alaska fashion, they included in the FAQs that there is no way that this can be vetoed or repealed for at least the next 2 years. And so that's something that we can at least hang our hat on for a 2-year period that we're going to be looking at this paid sick or some version of this paid sick in Alaska. So we'll need policies for this. Nebraska, actually, on the next slide, is a relatively similar plan, does provide sick leave to basically everybody who works in Nebraska, and the amount provided is based on the size of the employer, either 40 or 56. We're starting to see, these numbers, if you're recognizing, oh, I know 40 and 56 because a lot of states are following that path. There's a little bit of consistency there. There are obviously some outliers, which we're going to talk about in just a couple of moments, but Nebraska, very similar. If you are a smaller employer, it's 40 per year. If you're a larger employer, it's going to be 56. Both of these, because they are brand new, we are anticipating to get more guidance as we navigate. But these, if you've got folks in Alaska or Nebraska, having a policy to address this is going to be important to do that. Other big changes that we saw in the last year on the next slide, I'm sure y'all all got whiplash from Missouri, passed, put in place, and then immediately went away. So recognizing that it was repealed at the end of August, and so it is no longer something that we need to be concerned with. It'll be interesting to see if anything happens in addition to that. But then we also have 2 jurisdictions that already had paid sick on the books that have increased the amount that you have to provide. Pittsburgh was 40, now it's going to be 72. And of course, if it was a smaller employer, it was 24, now it's going to be 40. And so we are increasing that amount. And Michigan, hopefully everybody caught this one because this happened at the beginning of 2025, but after the last time we all met, they have gone to 72 as well by going, reverting to this Earned Sick Time Act instead of the Paid Medical Leave Act. So they're at 72 as well. Some additional changes that we saw in 2025. Again, these are laws that already existed, but some little tweaks within the law, little changes either in the reasons for use or the way the time needed to be documented, or there was a requirement in Cook County that came through that was requiring that people were accruing paid leave while they were using their paid leave, but that has been eliminated now. Cook County does have a written policy requirement that was added as well. Some of the other changes in Minnesota about when an employer can require documentation. Minneapolis at the end of this year is going to allow that paid sick leave can be used for bereavement leave. And so some of the other things that changed with the new ordinance is kind of aligning it a little bit more par with the state law, where there were some differences to try to make it a little bit more consistent. But again, we always anticipate we're going to see a lot of development in the paid sick leave space. We did last year. We are anticipating that again. So don't be surprised if you see some additional laws come through various state legislatures, especially if the idea is that the federal government's not going to be doing anything. And we do not believe that they will. So with that, I will kick it to Kathy and let her talk about our favorite state, California.
Thanks so much, Chelsea. So surprisingly, this is one of the lighter years for California, and we can see on the next slide a little bit of an overview of the legislation by the numbers this year. We had a lot of bills make their way to Newsom's desk. He signed 794, which sounds like a lot, but it is a decrease from the prior year. But really, the interesting takeaway here is how few of those impact employment policies and handbooks. We're going to dive into a few of the key ones starting on the next slide with our leave-related policies, because it wouldn't be California if we didn't have something affecting leave laws. Although this year, again, a relatively light list. We've got one expansion on reasons for use of paid sick leave, as well as an expansion of reasons for use for unpaid job protected leave. This is sort of tacking on to the qualifying acts of violence leave change that went into effect last year. But beginning January 2026, we can now have employees using sick leave as well as unpaid protected time to attend judicial proceedings if the employee or a covered family member are a victim of certain crimes and attending proceedings related to that crime. Really, one of the key things that this change allows us to do, and again, this is a rarity for California, is we get to streamline some policies. We used to have several different victim policies, and for those of you that know our handbooks and our California addenda as well, this will be a big change and will hopefully let you reduce that page count a little bit. So something to look forward to there. We also, not so immediately as 2026, but effective July 1st, 2028, are going to have an expansion of paid family leave eligibility to include taking care of individuals for who are a seriously ill designated person. The definition of that is going to track the CFRA definition of designated person, and again, not an immediate change, but something to keep an eye on for the future. And moving to the next slide, like I said, we're relatively light on things that impact our handbooks for California, but something to just take note of is personnel records will now be including education and training records. This is a change and something to just keep in mind in terms of how you're documenting training. You see there what those records need to contain, and really will come into play when you're responding to records requests and the like. Next slide, please. All right, another one that we're seeing a lot of chatter about, but that doesn't directly affect handbooks, but will affect standalone agreements and other related employment documents, is the stay or pay contract prohibition. And this is a chunky one that we're not going to spend a ton of time on today. Make sure you review the slides when you get them. But essentially, employment contracts entered into on or after January 1st, 2026 that require an employee to repay a loan or a debt to the employer at the time that the employment relationship concludes, those will be void. There are some really critical exceptions there. So this is one that I think some employers are getting a little scared of. You are right to take notice of it. We are here to help for any questions that come up. Moving to the next slide, please. All right, another one that's worth taking note of that we're going to spend very, very little time on are all of the plethora of changes that went into effect affecting pay transparency and pay data laws. The summary on here gives a really good overview, but these are changes that go into effect for 2026. They will affect your definition of pay scale, your pay reporting obligations, the categories that you're reporting under, also impact statute of limitations for wage claims. So again, something to take note of. And moving to the next slide, we're going to get into something that does involve an actual policy or a document. It's the notice of workers' rights. And this is something that employers will need to pay attention to when it comes out from the Labor Commissioner. They are supposed to develop a template notice by January 1st. We have not seen that notice published yet. We expect it'll come really close to that deadline. But essentially, the notice is going to be dealing with providing employees with very specific notices of rights related mostly to immigration and rights of notice of inspection and related topics such as that. So a relatively sensitive topic nationwide, but certainly in California right now, that the legislation took some action on. There's a related provision under that law about employees' emergency contacts. So this is, again, something to make sure that employees are aware of, that they have the opportunity to ID an emergency contact if they are detained at work or during work hours. So employers need to be giving employees an opportunity to make changes or to designate that contact. Next slide, we're going to get into a few very stray industry-specific things. We see an expansion of the meal period exemptions in California. Again, this shouldn't impact many of you, but again, worth taking note whether or not you're going to need those policies moving forward. Same with rest period exemptions. It's impacting probably a small segment of our listeners today, but for some of you might get you out of needing rest period policies there. So pay attention to that. And we do see some changes to independent contractors and employees' vehicle business expenses. A lot of this deals with how how employees in these certain categories are being classified and whether they're classified as independent contractors, but because of the overlap with expense reimbursement, it's worth paying attention to and might involve adjusting some policies if you have employees in construction trucking or dealing with commercial motor vehicles. So again, just a few things to pay attention to in California, a much lighter lift than in prior years. And I'm going to kick it back to Chelsea for the Southeast and Texas.
Sounds good. Thank you so much, Kathy. It's always unbelievable when our California section doesn't dominate the entire webinar. So it's almost a breath of fresh air. But I'm going to talk about Southeast and Texas, which is an area where we don't generally see a lot of developments. We did see some laws that came through this year in a few jurisdictions. So we did want to touch on those for those of y'all who have employees in some of these states. Starting on the next slide with some of the developments we did see in Georgia, Arkansas, and Louisiana. In Gwinnett County, Georgia, we did see the amendment of the definition of race essentially to become a version of the Crown Act. And so for those of y'all with employers there who have a policy on anti-discrimination, it is important to note whether you're going to put it in the policy or not, or just understand that this is now the law in Gwinnett County, Georgia, that race includes traits associated with race and national origin. And so that's an important development there. We also are recognizing in Arkansas, there already was a crimes victims leave, but they have expanded it, amended it to make sure that it's clear that employees can take time off, not just for themselves, but also as for family members or representatives of victims. So that is an important distinction from what the law was before. The definition of victim has also greatly expanded, so it has a much broader view of who can be a victim in those circumstances. And so this is obviously a law where if you've got folks in Arkansas and you're allowing them to take time off because they are victims of crimes or they are representatives, the definition there has become much broader than it was in previous iterations of this law. We saw a couple things in Louisiana, both towards the middle of the year. They already had a first responder leave in Louisiana, but recognizing the importance of folks who work in the public utilities, they expanded the definition of first responder to include folks who work, I guess, as either as a second job or volunteer, if that's such a thing, electrical linemen. So that is obviously an important new development because first responder would not have generally included these individuals. We also recognize that they did amend their protected classes, those who cannot be discriminated against, to include military status, very consistent with the way that federal law views this as well. But Louisiana wanted to chime in and add that to their state law as well. On the next slide, I'll talk a little bit about Texas and West Virginia. Texas took a big swing at delivery network companies this year. And so it's always interesting when Texas does anything related to employment laws, but these not only are important laws to take note of, but they also have policy requirements. And so that's just not an area where we generally see a lot of development when it comes to Texas. But if you are a delivery network company, it is important to note that Texas now now has a law that is even stricter than the state law would be for being under the influence of any sort of intoxicating substance. It requires delivery network companies to create a policy on the prohibition of intoxicating substance use so that there would be no ability for anybody who is logged into the system to do any deliveries to have any amount of intoxication whatsoever. And it's important, obviously, we recognize from a public service position that's a good plan, but this is a written policy requirement. So it's something that delivery network companies will need to do. It also requires the adoption of a non-discrimination policy that would prohibit delivery drivers from discriminating against their customers or potential customers based on their location or destination or race, color, national origin, religious belief, etc. It'll be interesting to see how this plays out. And again, it's unique. We don't get a lot of employment law in Texas, and this is an actual anti-discrimination law that applies for a company itself to utilize for its delivery network customers. And so it's an interesting little twist on this, but they did have this pretty expansive law that our Texas delivery network companies need to be aware of and implementing policies in this space. West Virginia, we also recognize, came out with their own version of a pregnancy accommodation statute that was towards the beginning of this year. But for those of y'all who have employees in West Virginia and you may not have been aware of this development, this came through. It does really highlight the expansive nature of their pregnancy accommodation rules, defining person very broadly, defining related medical condition very broadly, highlighting that lactation is covered, but elective abortions are not. It does include in the law various examples of reasonable accommodations. It is right now set to sunset as of 2030, and so it'll be interesting to see if they come up with another kind of substitute law behind this one, recognizing that there is a sunset that is on the horizon, pardon the pun. With that, I will go ahead and kick it back to Kathy to tackle some of the developments in our Western states.
Thanks, Chelsea. We can move to the next slide to start off with Colorado. We flew through California. We're going to slow it down just a skosh as we talk about these other states. Starting off in Colorado, we've got changes to the Paid Family and Medical Leave Act going into effect January of 2026. This change adds an additional 12 weeks of paid family and medical leave for a child that's receiving inpatient care in a NICU for the full duration that the child is receiving such care. And the amendments are really clear that this is an additional 12 weeks. And so that means that any parent with a child in the NICU could receive up to 24 weeks of PFML. That would be 12 weeks of bonding leave plus this additional 12 weeks for NICU time. So an important expansion there. And the AI Act in Colorado is a really interesting law that went into effect. It's a first of its kind. We're definitely going to talk more about AI later in the presentation. But for now, let's focus on Colorado's law, which goes into effect on June 30th of 2026. This law was originally signed in May of 2024. It was supposed to have gone into effect in February of 2026. Colorado delayed implementation. There were several negotiations that went on through Colorado's special session that ended up failing. And so now we've got this June 30th rollout. This law applies, as shown on the slide, to employers that use a high-risk AI system in consequential employment decisions and have 50 or more full-time employees. And what could be consequential employment decisions? That could really mean anything under the sun, but we're talking about decisions that impact an individual's employment opportunities. And the use of the word individual there is critical. It could be applicants or employees. And so that's going to be innately hiring, firing, and promotion. But there is a possibility that this could open the door to a wider range of practices beyond those, including performance management, disciplinary action, workplace surveillance, and a host of other things. So it's an important law to really dig into and take some time with and be thoughtful about how you're drafting policies around it. There are also various obligations under the law related to documentation and disclosures, risk analysis, and various mitigation steps to take. So a lot of work to be done in Colorado purely on that AI Act. And with that, we are going to talk finally about the equal pay reminder. This is purely a reminder, it's been around for a little bit, but just so you have it on your radar, that through July 1st, 2029, if you are physically outside of Colorado and you have very few, less than 15 remote workers in Colorado, your obligations under the Equal Pay for Equal Work Act are more limited. You only need to provide notice of vacant remote job opportunities. So just a note there. And with that, we're going to take it over to Washington, which has a lot going on this year. So starting off with healthcare, meal, and rest period waivers. Beginning on January 1st of 2026, there are additional reasons that meal periods can be waived for healthcare employees. And this would have to be pursuant to a written waiver that notes on its face that it's voluntary, that it can be revoked at any time, and cites to a variety of additional information and is in place before any waiver can be utilized by the employee. But provided you've got that documentation ready to go, then employees can waive meal breaks if they've worked shifts of less than 8 hours, and they can waive their 1 meal break, or they can waive their 2nd or 3rd meal break if they've taken at least 1 meal break during a longer shift. We also have changes to lactation accommodation for everybody. Effective January 1st, 2027, we are seeing that all employees must provide pregnancy-related accommodations. This is a change under Washington law or it currently is until 2027, that it only applied to employers with 15 or more employees. So we're seeing expansion there of those types of accommodations. A bigger change here, though, is the rate of pay, and that the breaks for expression of breast milk, as well as travel time to access a lactation location, must be paid to employees at their regular rate of pay. This is a significant change, and it differs from federal law. Federal law does not mandate paid lactation breaks. This is also one of the few places where I've seen discussion of travel time to access a lactation location as part and parcel of the time that's considered for that rest break. So that's something really unique to Washington that employers should be taking note of. Other changes that were done under this was also an expansion of the definition of reasonable accommodation. It's now been broadened to include scheduling flexibility for postpartum medical visits. The current law only requires this type of flexibility for prenatal visits. So again, we're seeing just a general expansion across the board under this lactation accommodation umbrella. And we can move to the next slide to talk about paid sick leave, because we haven't talked about paid sick leave enough. But there is 2 different expanded reasons for use in Washington. One that's already in effect and went into effect July 25th of this year, that allows employees to use sick leave for the preparation for or participation in a judicial or administrative immigration proceeding involving the employer or their family member. That should already be included in your paid sick leave policies. If it isn't, you're going to want to revise those to include it. And coming up January 1st, 2026, another new reason for paid sick leave is going to go into effect. That includes certain absences related to an employee or their family member's status as a victim of a hate crime. We are seeing, similar to California, a lot of these expansions relative to safe time. So that fall under paid sick leave, but are more safe time reasons for use. So definitely something to take note of. And following that trend, we do see on January 1st, 2026 in Washington, also a change to domestic violence leave, with hate crimes being added as a qualifying circumstance for leave. So time to take a look at both of those policies. There's also some really big changes happening in the Paid Family Medical Leave Act in Washington. And this is probably the meatiest of the changes we're seeing in Washington. So I'm going to try and cover as much of it as I can. Beginning on January 1st, 2026, we are going to be seeing a phased job protection eligibility expansion. Say that 5 times fast. So beginning January 1st, employees who have worked 180 or more days will be entitled to job restoration if they work for an employer who has 25 or more employees. That employee headcount threshold reduces each subsequent year to 15 employees in 2027 and 8 employees in 2028. If you had employees if you were an employer with employees that fell outside of the scope of those protections prior to now, you're going to want to take a look at those because your employees now qualify. We are also seeing a reduction in the minimum claim duration. So currently employees have to take at least 8 consecutive hours of leave to file a claim. That's being reduced to 4 hours. So that's going to give employees more flexible use of this category of leave. We also have health insurance continuation changes. Employers will now be required to maintain existing health coverage for employees on paid family medical leave, provided that the employee qualifies for job protection. So this is now a more closer alignment with FMLA standards to ensure the continuity of benefits during leave. These other changes that we're talking about, the minimum claim duration and the health insurance, those all go into effect January 1st. So coming up pretty quickly here. There are also new notice requirements that relate to combining paid family medical leave with FMLA. So under the amendments, employers can't force employees to take PFML, which could potentially allow employees to stack their family medical leave with their paid family medical leave. The amended law addresses this by extending employment protections to any period of unpaid FMLA leave where the employee was eligible for PFML but didn't use it. To enforce that requirement, employers have to provide written notice of an employee's leave allotment within 5 days of an FMLA request and continue issuing monthly updates at the leave period. So more documentation that I know everyone was hoping they would get. And there's also a new affirmative reinstatement requirement. Employees must actively exercise their right to return to work at the end of leave, and if they don't, they can forfeit their reinstatement rights. And this also needs to be provided to them in writing. We're going to move to the next slide to very, very quickly talk about background check changes in Washington. These go into effect in a couple of months, July 2026, and there are new screening practices. There's a lot on this slide. I'm not going to dig into it in detail, but basically this is all about when you can ask and how you can consider criminal history, criminal records, and arrest records. So take a look at the slides when you get them. You'll see a lot of information there. And we're now going to move very quickly over to Oregon to talk about just 2 final laws there on the western states. One, again, paid sick leave was expanded July of this year to include blood donation. So that's another qualifying reason for use. And Oregon Family Leave Act was expanded September 27th to clarify that employees can take leave to care for disabled children older than 18. And as I'm losing my voice and at the end of the slides, I'm going to kick it over to the next person for the next section.
Thank you so much. So I'm going to take it and talk about New England and New York. New York, again, like California, this was a really light year in New York, and we can go to the next slide. And so I'm going to focus here on New York City's paid prenatal leave, but as most of you know, New York State also has a paid prenatal leave that went into effect January 1, 2025. New York City, not to be outdone, had to enact its own, went into effect July 1st. They're very similar in that they both require 20 hours of paid leave in a 12-month period, in addition to the paid sick leave that employees are already entitled to. So it is an addition. You can't use some of your sick time to meet this obligation. And so the laws are really similar, but not identical. The New York City law does have a balance notification requirement. It includes the ability for employers to ask for documentation after 3 consecutive days off. The problem with that is that the New York State law does not allow for that. And so even though the New York City law, if you read it or, jump on and get a version from AI, it may say that you can ask for this documentation, but in fact, if you're subject to the New York State law, you can't. And then there's also the New York City law requires that you have a written policy in your handbook, and that it is very detailed. So if you are in New York City, we also recommend that you have one for New York, but it is absolutely required in New York City. And then just wanted to mention here, there was a small change to the New York City lactation accommodation law. Now requires you to have to make a refrigerator available. And so like the sick paid prenatal leave law, you also need a written policy for lactation accommodation in New York City. And so you may want to add this into your policy. And then on the next slide, these are the sad little two things that New York actually changed. One is New York jury duty pay. And so 11 or more employees, it went from $40 to $72. And then if you are a retail employer, there are some requirements to maintain a workplace violence protection plan and provide some training that went into effect June 2025. And I've included a link to the website where you can get more information on that. And so now we'll roll right into New England and start with Connecticut. I'm not really going to spend much time on this slide, but I did want to put it here. Connecticut paid sick leave changed substantially last year, January 1, 2025. The reason I put it here is because they phased in their law, and so it did apply to 25 or more employees. And now if you have 11 or more employees in Connecticut, as of January 1, this law is going to apply to you. And then as of January 1, 2027, it's going to apply to all employers in Connecticut. And so moving on to the next slide, we're going to talk briefly about Massachusetts. Again, surprisingly, Massachusetts, very quiet year. At the very end of last year, 2024, they did add an additional reason for use to the paid sick leave law. So some of your policy updates may not have caught that if it was done earlier in November. So you want to add this, and it's about time off for pregnancy loss. And then I'm just, because it is effective today, wanted to just mention that the Massachusetts pay transparency law did go into effect. And so if you have any questions about that, we have a bunch of folks that are up to speed on that one as well. And now we'll switch to Maine. We already talked about the fact that the Maine paid family medical leave law, May 1st. Maine also passed a reporting pay law as of September 24th. And it requires 2 hours of regular pay. There's some more detail in this slide that you can read, but it essentially operates the way most reporting pay statutes do. And so then we're going to switch quickly to New Hampshire. New Hampshire was surprisingly busy this year. So New Hampshire has passed a service member spouse leave. And so essentially what it's saying is that if you have a spouse who is involuntarily mobilized to active duty, that you can take leave for the length of active duty, but no longer than 1 year and 1 day. I'm not sure where the 1 day comes from, but that's what this statute says. New Hampshire has also put into place a childbirth, postpartum care, and infant pediatric medical appointments leave. This is an unpaid leave. So unlike New York City and New York, where it's paid prenatal leave, this one is about 25 hours of unpaid leave to attend these types of appointments. And so then finally, in New Hampshire, lactation accommodation, this has been in effect since July 1, but a written policy is required, so we wanted to mention it here. I'm going to go on to Rhode Island. Rhode Island was another one that was a little bit busy. They are the first state in the country that has amended their fair employment law to include menopause. And so now employers have to reasonably accommodate menopause, including the effects of vasomotor symptoms, which essentially are hot flashes. So things like fans, maybe cooler uniforms. It may also involve some time off. So again, we can help with those, but you should adjust your reasonable accommodation policies. Rhode Island temporary caregiver insurance, 2 little changes. Now increased from 7 weeks to 8 weeks, and also includes some benefits for bone marrow and organ donation. The times are a little more limited than other types of leave under temporary caregiver. I also wanted to put here this overtime and premium pay clarification, and folks can look at this. Rhode Island is the one state that still requires premium pay for work on holidays and Sundays. And because I know people are going to ask, I did put a link that will take you to the holidays that are covered by this law. But take a look at this, because if you are a retail employee, the way that you have to calculate overtime is a little different than if you're a non-retail employer, sorry. So you'll want to take a look at that. And then the next slide. Oh, I just wanted to put this is not a policy thing, but Rhode Island has passed a pretty burdensome wage notice requirement. It goes into effect January 1st, requires you to provide people with all of the things on this list. It has to be acknowledged. It includes your time off policies, your leave policies. So take a look at this. And again, we have reached out to the department to try to get some additional clarity on this, and they keep telling us they're going to be posting some more guidance soon. So we keep looking for that, and probably will do some sort of webinar on this topic as we get more information. And then finally is Vermont. And because we're short on time, I'm not really going to go into this one, but just there were significant amendments to the Vermont parental and family leave law. It also includes some short-term family leave. And so this is really going to require a complete redo of your policy if you are subject to this law in Vermont. And so we have a template policy and are happy to help with that. I'm going to turn it back over to Chelsea to hit the Midwest.
Thanks, Jean. And I'll just spend a few minutes talking about the Midwestern states. Illinois will kick us off. Illinois was pretty busy this year. They created a brand new NICU Leave Act. Illinois is always on the forefront of thinking about these types of issues, so we weren't surprised to see this in Illinois. It is additional time off in addition to FMLA for employees who need time off to care for a child who is in the NICU. And so that is a brand new law, and we do recommend creating a policy for it. And so we can obviously help you with that as well. Other things that we saw in Illinois on the next slide, a confirmation that lactation breaks all need to be paid in Illinois, adding protections to VESA, their anti-violence law that employees can use their company issued equipment to record acts of violence and not be punished by it, and it does require notification of that. There's a new funeral honors details leave that's going to provide employees with time off, and expansion of blood and organ donation leave to part-time employees as well as a little bit of an expansion to the meal and rest breaks for minors in Illinois. We did talk a little bit about Minnesota already when we touched on some of the expansion for paid sick, but very importantly, Minnesota expanded and clarified its meal and rest break requirements. It does now have very specific timing and additional requirements around meal and rest breaks. We are expecting regulations, and so there will be additional information, but for those of y'all in Minnesota who had relatively vague meal and rest break policies, we do have more specifics now, and so we'll want to make sure that we build that into your policies as well. We also have seen some expansion to EEO categories in Minneapolis, including things like justice impacted status, housing status, height and weight, and intersectionality, which we're seeing as a trend across the country. So we are seeing some development in Minneapolis on that as well. Then some other Midwest activities. Surprisingly, we did see something from Indiana this year on our next slide. That's going to be an annual school conference leave, which is something that we do see in a number of states, but Indiana joined the fray this year. And we also saw Wisconsin expand that arrest record discrimination defines that to include non-criminal offenses. So you couldn't, for example, terminate an employee based on a municipal citation. So that's what we saw from the Midwest. And again, I know we're moving very quickly, but you will be getting these slides. So don't worry about missing some of this, and we're all easy to contact. Kathy, you want to give us a little bit of a summary on the importance of why a handbook is necessary?
Absolutely. This is basically the, why are we your cape wearing handbook crusaders that we are. So we're going to move to the next slide to kick us off. Why do you want to have a good handbook? There are obviously legal obligations for certain policies that need to be in writing, but there's also immense benefits to your workforce and to your employees for having one place that really establishes what the uniform expectations are and gets to highlight and showcase what you're providing to your employees. What makes it amazing to work at your company? What time off do they get? What holidays do they get? What other benefits are they getting? Tell me about meal breaks. Tell me about all the things. So it really helps to outline all of that in one place and to do it really consistently. It gives employees to that end something that they can rely on, which also helps to reduce unnecessary questions to their supervisors who might give rogue responses or might have different perspectives. And it also allows you to obtain that your employees have acknowledged and understand what those expectations are. So that's going to be valuable when you're in litigation, when you're doing any performance management. If anything comes up, they saw these policies and they understood them. Moving to the next slide, we are going to talk really quickly about most of this, but why do you need written policies? A lot of the time because it's required. Even if it's not strictly required under the law, it's often a recommended best practice. There might be something new or different or something that you want to correct in the workplace. And on the next slide, gives you a little bit of an overview of the work that we do when we're starting to draft policies for you. There is a whole host of light reading that we're engaging in. And on the next slide, you'll see a little bit, again, high level, what does a good policy include? We want to make sure that we're spelling out all of these different categories of information to employees. And we do the laboring of making sure we're crafting something with all of this in mind when we're working on our handbooks and addenda for you. And I'm going to kick it back over to Chelsea to talk a little bit about how we've been helping employers with that.
Yeah, thanks, Kathy. We just wanted to give you a reminder of who we are and what we're here to do before we give you the CLE code and let Jean talk about a little bit of the trends to wrap us up today. We have a team of about 40 40 attorneys in every level who have all been trained on how to draft policies, on how to help navigate these types of issues. And we are here and ready to help you navigate handbook season 2026. We have our own internal materials that we've used. We've updated all of our templates already for 2026, so we are ready to help y'all do the same. And just so you know, we typically utilize a questionnaire. We get information from you. We can certainly help turn in this information into a workable handbook for you. Or if you already have one, we use our materials and our references to be able to review that and make it compliant. It is, on the next slide, we can see it's something that is completely customizable. It can either be a brand new from templates, or it can be used, like I said, to review your own materials, but it isn't something that is just completely plug and play or off the shelf. I don't think it would be good business practices just to hand somebody a handbook, because there is so much risk and nuance involved in creating a good handbook that will operate in the way that Kathy spoke about just a moment ago. And so it's really important for us to be able to work with you in order to do that. And on the next slide, we really can demonstrate what it can do, how we can help you, and really help make it a very cost-effective solution. And so with that, I know you all have been waiting for the CLE code. It is on the next slide. There is a scan code, which I think is so cool. But the code, for those of y'all who are waiting for, it is SS, as in Seyfarth Shaw, 2004. It was a great year. SS 2004. And you can scan the little code and fill it out. And to wrap us up, I want to give Jean the last just few minutes to talk very generally about the trends that we're seeing and expecting to see for 2026 and beyond.
Thanks, Chelsea. So on the next slide, you can see that we're talking about some trends, as Kathy mentioned earlier, artificial intelligence. This is an area where we anticipate seeing more legislation related to how employers can use AI, but we're also getting a lot of requests for policies to give to your employees about how they can use AI as part of their jobs. And so, you know, if that is something that and we do recommend that you really think about that and that your employees have some guidance around what is allowable and what is not. And then we continue to see robust accommodation policies being things that either are being asked for or that we recommend. This is one area where the administration is still interested, particularly with respect to religious accommodation and pregnancy accommodation. And because the standard for pregnancy accommodation is different than for disability accommodation, considering having a separate pregnancy accommodation policy is something that we are looking at and talking to lots of employers about. Social media policies. This has become a huge kind of cultural flashpoint. As many of you know, following most recently the Charlie Kirk assassination, we had a lot of press around people getting fired because of social media posts. So, one thing we would say is that these are hard issues to navigate. You need to really understand and think hard about what stance you want to take as an employer, but we can help you then develop a policy. And, generally we do recommend that you address off-duty posting, but make it clear that it's only if it impacts the workplace. There are some National Labor Relations Act issues that you need to be careful of, and that you're not prohibiting people from talking about wages or hours and working conditions. So then on the next slide, discrimination and harassment. We're continuing to see an expansion of protected classes in some states with immigration status, a lot of family responsibilities, and then, as I mentioned, in Rhode Island, menopause. But unlike other years, we're also seeing a shrinking of some protected classes in other states. Some states have passed laws defining sex as based on biological characteristics at birth. And you can see kind of the list here. There are almost half of the states that have passed laws that actually include a protection for gender identity. One of the things you want to make sure is that your policy aligns with both state and federal law, because currently under the law, gender identity would still be protected under federal law. Diversity, equity, inclusion, and belonging, difficult and divisive issues. If you need anything on this front, please reach out, and we're happy to help with that. And then finally, the very last slide just talks about the continued expansion of leaves and time off, and most of these we touched on. And that is going to wrap it up for us today. Sorry, we see we're 1 minute over time, but we appreciate you all joining us.
Thank you so much, Jean. And just for everybody, if we didn't get a chance to get to your questions, we are going to take those offline and respond to you. If you want to reach any of us, our emails are here. We certainly are happy to help you. We know this is a lot of information in a relatively short window, but that's because there's a lot to do. And so please reach out, and we are happy to help with any handbook needs you might have. And thank you for being a part of our webinar today.